sometimes that works and sometimes it doesn't. I finally accepted that I can't be solely responsible for whether or not the folks in front of me are paying attention. And that's what even the students will do. Yeah. It's like, I think you're fiddling on your computer. I can't take that personally.
I know.
That's you, that's not me.
Last week, get this email, I'm in Chicago for an assessment conference, and we teach during the summer. And I get this email, this adjunct is so mad that this student was on the email. And she had a guest speaker, and she said to the whole class, everybody needs to be paying attention to the guest speaker, not doing anything else. So he closes, and then she talks with him in the hall, and now she wants me to dismiss him from the class.
Oh, good grief.
And I'm like, what did you say this? Hello, and then the email was, if you don't dismiss him and give him 100% refund, I'm quitting.
Closer than the one in Chicago
In the
will be.
middle of the term.
Oh, you've already scoped that out.
Oh, yeah.
So I know what you're saying, when,
Even
you
holding
know,
tables.
you're not responsible for your They choose.
I'm not going, so.
I mean, when I have,
Yeah, the answer
the few
went out
times,
on my blog.
because talking guests into coming to Athens is harder. And we don't
love it.
And so,
You didn't want to sing last night?
somebody's gonna have up half a day.
No, I didn't.
Yeah.
We've been
Right,
tracing
and,
around.
you know, so it limits what we can do. And, but, you know, I would, the class before I had,
Lovely art gallery.
I would say, you know,
Where is it?
you reflect on me, you reflect on yourself. You're not liking this person. And that's all I'm gonna say.
Right.
Yeah, they all they see is this, yeah. They're not walking around in the back.
It's time to go there.
Yes? And I was just saying, you know, what the Lions were doing, because if I took it personally,
How are you?
you know, I figure that one's really good if I start with that. So what I'm picturing is going to happen, I don't know if any of you are from the Atlanta area, but in the year after 9/11, when the Atlanta Symphony performed, they would open the concert with the national anthem. And the conductor would walk into the room and start it before he got anywhere close to the podium. So that's what I'm imagining Sarah's going to do as she gets here, is start everything off with a bang. And the first time I saw them do this, it nearly made me jump out of my seat because, you know, when a full orchestra starts that tune, it's pretty dramatic. But, you know, I don't have all the answers to the questions I was going to ask my co-presenter. It's one of the reasons I agreed to do this.
Who in life really has all the answers?
That's exactly true. No, she's probably wandering around downstairs looking for me. Yes.
Running everywhere, yes. All the time.
All the time. Actually, I told them you were going to key up the Star Spangled Banner as you walked in.
Oh, I was? I can sing it.
That's all right.
Let's not do that.
Let's
okay.
don't do that.
Cool.
Yeah, so we'll pretend like we're starting. I'm Maureen Cahill. My title is Student Services Librarian, and I'm at the University of Georgia. I teach, which I'll tell you about, a class that involves some technology, and we're taking over first year legal research instruction next year. Been teaching ALR for 3 or 4 years, and until this year, for the past 4 or 5 years, I've been teaching research and writing in our LLM program to foreign lawyers. So, you know, standing up here in front of you, I'm not paying any attention to you because I know how rude students are to the folks at the front of the room.
And I'm Sarah Malden. I am the Director of Library Services at Smith, Gambrell, and Russell, right here in beautiful Atlanta, further up the very long Peachtree Street. And I have a big interest in technology. And really, I'm way more interested in hanging out with academics than with the other firm librarians. So that's part of why I care about this so much.
Just for us, how many of you are librarians? How many of you teach? Okay. Are the rest of you technologists?
And who in here practiced ever?
Okay.
Okay. Was it a long time ago? A little time ago?
Long time ago.
Okay, cool. Because there are a lot of differences now. So
yeah. I quit practicing in 1996, and I practiced, I was actually still an employee of the law school then. I was in a clinic. We provided legal services to the state prison population and had about 40 students a semester who came through and helped us do that. We had, in the early 90s, an intranet We had forms that we could fill. We had actually simple expert systems that we used. And so I'm horrified to learn 20 years later what law firms are doing, because I know the world of technology has changed. But
and a quick note here, law firms, as my finance partner says, are on the leading edge of nothing. So just keep that in mind.
yes. So, on to the presentation piece. Let me tell you the story of our technology class. First, it started with a grave mistake on my part. I thought the hardest thing was going to be getting this class approved. So I was over-inclusive. I said, oh, please just let us teach a 1-hour class. We'll call it Research and Technology Skills for the Georgia Attorney. Sounded really sexy. But notice I put in research and technology. So I've got
Georgia.
In Georgia. Yeah, I've got a 1-hour class. I'm going to do Georgia research and I'm going to do legal technology.
And who did you think was going to join this class?
Well, you hear how I'm billing it. I figured the vast majority of our students who are not going to big law, who might in fact be hanging up shingles, who expect to practice consumer law in Georgia, is who I'm going to see. So I had prepared that great class. Half of it was Georgia legal resources. Half of it was talking about, how you can use fast case and leverage other kinds of inexpensive resources to actually have everything you need without hawking the firm to have legal resources. I wanted to talk about how you decide whether or not to keep your firm's stuff in-house or in the cloud. How you decide what to buy technology-wise. How to decide if you're opening your own firm and make it work. It's like, I'm never going to have a piece of paper in this office. Or maybe I'm never going to have an office. I'm going to have a virtual law firm. I wanted folks to understand the online marketplace. I wanted folks to understand what their website should look like, how they decide what devices to buy, who should support them, how they choose a vendor, if they're going to deal with the cloud, that kind of stuff. So what did I get? I got 13 folks, and when I looked them up the spring before I was going to teach this class in the fall, 11 of them already had big law jobs.
This is when I got excited.
Yes, they thought, of course, it's a librarian, it's 1 hour, we're going to just sit here, she's going to blather on about something we don't care about, and it's a credit, and we're third years, we already have jobs, we're just checking in, we're really not doing anything else. So what they didn't realize was that I was going to spend all summer reading about how technology is punching big law in the face and trying to think about the kinds of things they might need to know. Now, like a dummy, I was doing this on my own. I didn't call Sarah.
Even though everybody should call a firm librarian every once in a while.
Yeah. Well, you think these people are busy. They don't care about what we're doing.
No, we do. A lot.
They do because they have to deal with our students. And the more painful we make that for them, the less they like their jobs. And maybe that's good for us. Maybe we can talk them all into coming and working for us.
If you can make it so we don't have to have JDs.
Yeah, I know. That part's hard. Academia being what it is. So what we decided to do, I wanted everybody to appreciate at least the concepts of what technology is doing to the practice of law, not just at the big firm level. I wanted folks to understand. So what we had students do is really short research and really short presentations or papers on a lot of the companies and factors that are impacting the practice of law, even at the consumer level. I wanted them to at least understand that. But then I also wanted them to have personal technology skills. And I don't just mean being able to use styles, although I definitely mean being able to use styles. And I definitely mean being able to bust a PDF in half or take 2 PDFs and put them together. I mean, those are just, in fact, we did most of that in a flipped environment. We had some videos that we had produced from lunchtime programs we'd done at the law school. So we had folks watch these videos and then we tested them on these skills. But when I say personal tech skills, I also mean, what do you understand about how you pick your personal passwords? What are your actual practices picking your personal passwords? What do you understand about how it's probably true that by the time you pick your password, it's already insecure? What do you know about things other than passwords that can be used to secure things? What do you know about social media best practices? What do you know personally about organizing what you do and how you keep your files so that you're not always chasing after something? Can you organize your email? Then we talked really basically about the notion of practice management and what practice management can do for a lawyer and a firm, and the various modules that might exist in a practice management system. We made them play a little bit with it, but since they're all going to have some iteration of hacked together SharePoint when they get out into practice, we didn't go into that very deeply. We talked about what expert systems are and how 4 law firms in the whole country are actually really using expert systems in a client-facing way to...
leading edge of nothing.
Yes, although the ones who are doing it are doing a very good job. And I wanted students to be impressed with just how good that is and how much it can change what the firms are offering and change what clients expect from the firms. The HR compliance system that Littler Mendelsohn is pushing out to their clients should be changing the way everybody's practicing law. Because in employment matters, if I were GC someplace, I'd say, why are we looking at anybody but Littler? They understand that we have certain day-to-day needs, and they're building systems that we can use on a day-to-day basis, and all we're paying them is a subscription for that. We are not paying legal fees every time we look at this compliance undertaking, and we don't want to. We can't. It means we don't have to hire our own lawyers that we can call up every day for these compliance issues. So we talked about that. Eyes kind of glazed over when we did. We talked ad nauseum about professional responsibility, the ethics rules that impact how you use technology and what technology does to what you produce. We made them, again, going back to personal skills, we beat them up one side and the other about presentation software. And we talked about how software does not have to ruin your presentation. For one, that's one way you can do it, but we talked about at the same time, graphics are really important. We talked about the few studies that exist showing when you do have physical, visual, demonstrative representation of what you're saying, it can impact the results that you get from a jury. And when they did their little presentations, we made them try to use presentation software to demonstrate at least an appreciation of how you use visuals to improve your communication, as opposed to just make sure that nobody's looking at you, they're looking at the screen, which is the way I always used presentation graphics. It's like, don't look at me, look here, and then I'm comfortable talking to you. We talked about courtroom technology. We made them all We assigned them a county. We made them all call around the courthouse and figure out who can tell you what's available. If you can bring your own stuff, what the judge you're appearing in front of expects or will not let you do, just to get an idea. Courtroom technology, even filing technology in Georgia varies widely from county to county. And you have to appreciate that. You don't have to go far from Atlanta to get to a county where you still have to file everything in a paper format. But you also, we just changed our magistrates courts, which are essentially the small claims courts, which are the courts more than 90% of the litigants come to without a lawyer, just moved to an online, an e-filing system exclusively. Hey, there's a good way to cut down on the number of pro se litigants you have coming to court.
Yep.
But, you know, these were the things I wanted our students to understand, but I still hadn't talked to Sarah. So I still didn't know, what do they see when they get to practice? What do they need to know? What do they arrive, you know, because they're hiding from me what they know. They're not going to admit they don't know something out loud to me. They may demonstrate, I tried my very best to make them demonstrate to me what they did and didn't know. But, you know, I wasn't going to get many admissions out of law students. So tell us.
Tell us, all right.
How do they come to you?
Well, they come to me, I have the best summer associate class I've ever had in my whole life. I've been doing this 13 years, and my summer associates are absolutely certain they know nothing. It's been great. The first question they asked when they got thinking about how we use, you know, legal research platforms was, how much does it cost when we put it in the big box? And I was like, $99 when you put it in the big box. And they went, and then said, I'm never going to search in the big box again. Which I was like, no, you don't need to be afraid of it. You just need to know how to use it reasonably. And I am a very hands-on law firm librarian. I am probably not like any law firm librarian you have met, probably. I don't spend my life complaining, really. And I expect that they will come into my office and talk with me about anything. If they want to talk about technology, if they want to talk about research strategy, if they want to know where to go to dinner, I'm cool with that. Come on in. And they do. And in fact, if they don't find something, they will often be told by their attorney, did you talk to Sarah? And if they haven't, the attorney makes a stink eye at them and says, well, you better. Because that's how they do it. So their research skills are not bad. I'm totally cool with their research skills. They don't always remember that there are regulations. They don't always think different ways about things, but that's okay. Y'all are doing a great job giving them research skills at this point. Actually, go y'all. But, oh my goodness, a whole lot of people seem to believe that because they were born in this world of, after 1990, that every one of them was born knowing how to use Word. It just popped right out of the head of Zeus, ready to use Word. They didn't. And they can all put their fingers on keys and words come up. That's all they know how to do. That's it. We're done. Excel, unless somebody has ever made them use it like they were in a statistics class or something, they have no clue. They're like, what is this thing? Why is this happening to me? And you know what? If you're a litigator, you're probably the most likely to use Excel because you're going to get client data, you're going to get all this stuff that you have to be able to sort and whatever. And also, Excel is used for way more than numbers.
Yeah. And just so you know how much I didn't talk to Sarah, Excel was the thing we decided to take out of our class. Because we thought, sure they're going to use Word, sure they're going to have to manipulate PDFs. How many of them are going to touch a spreadsheet?
All the time.
All the time. But we didn't know that.
Yeah, and we use it for all sorts of different things. I mean, litigators, yeah, they deal with client data, but they're also like, it's a great place to start your privilege log. Because then you can sort stuff. How cool is that, right? I need to know all the things that are emails that are in my privilege log. Great, wonderful. But if you don't know how to sort it, And then the KIA audit came along, right?
Sure.
And it scared every IT director everywhere. They went, oh my goodness. Well, first of all, what is my managing partner going to say to me about how to get this stuff better? And how am I going to do it with a group of people who, like law students, are sitting looking at their, if you sit them in front of a computer in a training room, their email is going to be up the whole time. They're not going to think about the words you're saying, okay? At all. So, traditional training's not going to work, right? Because I'm busy, I've got all this stuff to do. You're taking billable time from me. And the second they come in as an associate, they're thinking, billable time, billable time. I can't learn how to do something because it's going to waste my billable time. Guess what? You're going to waste way more of your billable time when you are, putzing around with Word or Excel. So you better learn it. And it's that assumption that everybody knows how already, because there are menus, there are things, you can do it. Well, they hide stuff up in those menus. They hide really cool stuff in those ribbons that you'd never know was there.
And did you notice that Sarah said Excel is a really cool tool to use for your privilege log? Now, she works at a giant law firm, People drive Brinks trucks up to the door all the time and, shovel money out.
Yeah, they do. It's really nice.
Yeah. They don't have an electronic system in place for people to manage privilege logs. Mm-hmm. Folks have to go to Excel or something else that they jury-rig to do it in order to accomplish that task. Now, first of all, to me that doesn't make sense. But second of all, it's an expectation that we need to have of what we need to give students, even those who are going to the Mint to work, about what they have to be able to do. Mm-hmm. They have to know enough about the kinds of technology tools that are out there to jury-rig some of the everyday tasks that computers can help them do, because their firms haven't thought to do that for them.
Mm-hmm. And one other thing and yet there are some attorneys that would never do that because they have a particular matter or case management software that they like, that they have been able to tell IT, I really have to have this. And IT says, great, you have your seats, and we will not think about you again.
You're telling me there are attorneys in your firm that have software that other attorneys in your firm don't have?
Yes. We have one attorney that has WordWrite because he said, I love this, I want it, get it for me.
But you're saying even practice management software.
Even practice management software. Because, there's a particular reason for this in my firm that I think you'll find in other firms as well, and that is that we have grown by acquisition. So we started out as one firm in Atlanta in 1893. And then we continue as one firm in Atlanta all the way up to 1986. Two firms merge, become a bigger firm, which by Atlanta standards, we're big, except that we live next door to King and Spalding and Alston and Bird. And then they start, let's see, we need to move out. So they bought a litigation firm in Jacksonville, Florida. And then they bought an IP firm in Washington, D.C. And then we integrated in 2 different firms in New York City. And, we now have an Austin office where, of course, we're considering how are we going to acquire our way into the Texas market. And we're always looking at acquiring. Well, all of those folks They came from firms even smaller than us. So they're used to doing things their way. Hartman and Craven was integrated in 2014. We started integrating them in. That's the 5th library I had moved in my 13 years as a private law librarian. So I've moved more than anyone should. But, and they had things the way they wanted them.
Now, I'm going to interject, if I
Yeah.
may, with a question. All these mini firms, is there anyone in the big firm, the over firm,
The Uber firm.
yes, who is thinking enough about technology policy and the technology tools that are used firm-wide that there is a process for integrating differing technologies throughout the firm?
We have an IT department, and we have an IT director who is amazingly good at managing things. We have a help desk that is mostly word processors that got up to being a help desk because we don't like to fire people. And then we have the sysadmins in between. And so our IT director is doing his best to, kind of manage these things. But partners who are used to owning their own firms are scary. And they will say, if I don't have this, this is what will happen, and this is how you will not have a job, and this is all these things.
Does your IT director have a seat at the table when technology policy is made?
He is on the technology committee.
Okay.
They will not let me be on the technology committee. I ask too many questions. And I'm a problem. So yes, there is a certain level of that going on. But then we're also blindsided by stuff. Like when Fulton County changed e-file vendors. All of a sudden.
Yes.
We didn't get a notice, except from the e-file vendor that was going away, that we needed to have, everything was going to be e-filed in this new system. I had to get a credit card for the e-file system. I had to, and how I got in charge of this, I don't know, but I did. I had to do a whole lot of things, and I had to train everybody on how to do this. Because other courts, it was the Fulton County State Court that went first, and then the Fulton County Superior Court went, and you know how they told people? They put it on their website. How many people go and look at the court website every day? Nobody. So one of our paralegals happened to be on a list from something very long ago, and that went out to that list. And she called me and said, hey, you gotta do something about this. And I went, yeah, you're right, okay. Superior Court's kind of important. And now we've got all these courts that are going, and it's a mess. It's a good system in that it's the same, no matter where you're filing, but it's a mess in that I have to run 2 reports and look at a credit card statement to reconcile billing. That's not so good. And we have this other system called Peach Court, which is in some counties compulsory, and in other counties is simply a convenience. And believe me, in Georgia, having a way to file in one of the other 158 counties without going there is a major convenience.
Georgia, by the way, is the largest geographic state east of the Mississippi.
We also are the state with the second most counties. The only state with more counties is Texas because they need them. We don't, but hey, we got them. Yeah. And we're also very county-oriented.
Is it possible that an associate would wind up, after one of these mergers, having to use tools that they'd never seen before?
Oh, absolutely.
Okay.
And a lot of these smaller firms, like everybody at Hartman Craven, they had simply bought a new computer when somebody needed one. So they had like 3 operating systems, and everybody was on a PC. And I see everybody, has a Mac, and I know that every law student has a Mac. Tell them now that that's not going to work when they go out into practice. It's true, though.
But don't you think that will change? Because if we're 5 years ago was kind of when we saw the Mac boom. And so how long does it take somebody to become a partner? Like, 8 years or something.
Oh, well, actually, the partner track is going away. I mean,
Well, my point is, you know, you get people who love their Macs, were forced to get a PC, they're now in practice 5, 10 years. I think we're gonna see a shift.
First of all,
And I worked, you know, I hired an attorney and she was using a Mac. I mean, that
Right.
she gets to choose. And they're also living back and forth. And it's a matter of like what they have time to do within law school, and do they have time? They don't have anyone to support everything that needs to be supported for a PC.
it's not that I need you to make them stop using them. I just need you to make them know.
Oh, yeah, we tell them that.
Yeah, absolutely. That you know, that it's gonna be how it's gonna be at every firm, and every firm is a special snowflake. I know that's a shock, but every firm is a special snowflake.
yeah, I mean, and Apple's going to have to get better at enterprise computing
Right.
before that change is going to
because-
happen.
and there's a big
Because-
difference here, too.
Because that's what Microsoft focuses on, is
Yes.
enterprise.
Enterprise,
servers
absolutely.
and server software.
Yes, and now, but there is a difference. If you're in a managed device firm, you're getting an iPhone because they do a really good job of managed devices. So, yeah, so you're going to have a PC on your desk and an iPhone in your hand. But more and more firms are also now BYOD. So, which also changes the way your phone is yours.
Yeah, tell them what happens
Okay.
to your devices.
So I got, I'm an Android girl, sorry all you Mac folks, and I'm a serious PC girl. And I got my newest Android, and I was happy, and I had the fingerprint identification, and I had some, like a 2-factor thing, and I was really excited. And I went in to take in my phone to get my RSA key and my email put on there. They made me take my 2-factor authentication off and put in the 4-digit code. I actually changed it to a 6 later without telling them, because I was like, well, you all should, but hey, whatever. And now my phone is, yes, it's mine. It's completely mine because there's no partition. But if I lose it, if I can't find it, whatever, I have about 2 hours in which I'm supposed to tell IT, day or night, and they will wipe my phone completely. All right? So it's not mine, is it? I pay the bill, all that. They do pay for my data, but they don't pay for my phone, because they figure I'm going to use that on my own anyway. Well, yeah, I'm going to use my data too, but all right. And the fact that they can do that with my property is something that is also has to be understood and remembered.
What makes it a device that they can control? What's the critical factor?
It is that they put email on it. There is now possibly client confidential information on my phone, so it's not mine.
Yeah. So if you have access to the firm Outlook on your device, that device becomes the firm's.
Mm-hmm.
And that's becoming closer to the norm, I think.
Yeah.
That fewer and fewer firms are actually giving people
Mm-hmm.
devices. They are just saying, no, bring us your devices.
Now, and this is very different because my husband has worked corporate and he's worked at a consulting firm. Both times they have handed him a phone, but they've also handed him a PC. And it was always an iPhone and a PC. So there you go. It's even in places that aren't law firms, they're still very PC oriented. All right, so
Okay.
And Outlook is a huge deal too, right? Because everything that we do in our firm lives under Outlook. Everything. So because they say, oh, attorneys have Outlook open all day, right? Yep, they do. And so our document management system is attached to Outlook. That's where you go to go do stuff. But that leads to one very big problem. Let's say, like it did about a year ago, some street working crew is going out there doing some road work, and they snap the cable that goes from our office to the, the center that the fiber optics are going through. Can anybody do any work? No. Because you have your documents under something that's attached to email. Also, this morning, right now, right up the street, right now, they are doing a cutover from an older version of our DMS to a newer version of our DMS. So from 6 a.m. till noon, no one has access to their documents unless they were proactive and checked them out ahead of time. And how many attorneys do you know that are proactive enough to know exactly what it is they're going to be doing? Other than why they're working at 6 a.m. on a Sunday, I don't know. But how many of them do you know that are likely to do that? So they're just going to, they're just going to be I'm mad that you did this to me.
What you thinking, Ken?
Well, one of those is a communication and standard issue. The other issue isn't so much that it's Outlook, it's that you're talking about cloud-based storage. And it's if one's going to run one's office with cloud holding anything, if possible, the firm should have alternative internet providers.
But it's not cloud. It's actually on servers in our offices and at the colo, but it's not in the cloud.
No, it's not in your office.
Yeah.
So wherever your colo is your cloud.
Well, yes, but it's not the cloud like students are thinking.
It's not a third-party cloud, but it's an off-site location, and whenever there's an off-site location involved, if it's critical data.
Yeah, I didn't say our IT department was any good at it.
No, I'm not saying,
Yeah.
I'm not accusing anyone
Oh,
of anything.
good.
I'm just saying, best practice.
Yeah.
If you're a business that relies on internet connectivity, you have an alternate internet path.
Yep. Yeah.
And law firm IT departments have, yes, they have the biggest budgets. Even though my managing or my finance partner keeps telling me I have the largest discretionary budget and why am I spending so much money? No, I promise it's the IT department that has the biggest budget by far, and nobody thinks hard when they buy new things. They think real hard when I buy new things, but because they see that as critical to the firm. But they also say, you know what else is critical to the firm? Me, partner, getting a good draw this month. So it's a constant tension between what is the absolute best practice that we could do, what if we lived in a perfect computer world we would do, versus, well, that one's really expensive. If we go one down, that'll be okay. And so it's not always big picture thinking. Well, it's never big picture thinking. And it's not always, it's the best practice for the moment. It's not necessarily the best practice for 2 months from now. I mean, it's definitely driven by cost.
Yep. How much, so you say everything is coming through Outlook. What do my students need to know about, to start with, how much of their communication is coming to them via email?
A lot. Law firms are still super email heavy. They will be, and so everybody.
Internal and external?
Internal and external. We don't even have a messaging service on our machines.
Okay.
So you can't, I've been in firms that have had it where they can say, the server needs to reboot, it'll take 2 minutes, and then, because people will look at the little thing that pops up, they won't necessarily look at their email for that kind of information, because that's not important to me.
What you got, Ken?
Your attorney who's giving you emails with clients,
All the time.
client confidential information,
All the
are
time.
they encrypting anything?
Yes. Just as of not very long ago.
And how does that happen, and what does an attorney need to
All
understand
right,
about that?
so what happens is your email, so everything lives in your email, right? And every time you attach something to an email, and you can do two things. You can attach a copy from the DMS, or you can attach an NRL from the DMS. The copy is just its own little thing wandering around,
And what's an NRL?
An NRL is an actual link to the document in the DMS. So that only works internal. So if you're sending something external, it's going to be a copy, or it's going to be a copy. And so this little thing will pop up from pane on the side, and it will say, I have detected that there is metadata in your document. If you're sending something internal, you just ignore it because it won't take anything off unless, you know, it sees something that's, but how it would have gotten in is the first question, and we hope that that didn't happen. And so, but if you are sending something external, like say a marked up document, if you don't click the little button that lets you select what needs to be removed, it's going to take all your markup off automatically without you knowing that it did it because you didn't remember because you were just like, oh, why is this thing taking time to do something? And that's so, and yes, and from that thing, you can also choose, does this need to be encrypted? Do I need to send this as something with an encryption key? They've had that since last September, and that's it.
Yep. But it's still a choice.
It is still a choice. You could somehow send this out with no metadata stripping and insecure.
Was
Like,
there training on it when they installed it?
yes, there was training, and now we are going through a god-awful selection of training videos from a vendor that everybody has to do once a month, and they tell you about metadata is, which is true. That is like a big story to a lot of people that I work with, that metadata is a thing. But it's also, so they did the training, and it does pop up. I mean, it's there. It says, excuse me, pay attention to me, pay attention to me. But that doesn't mean people pay attention. Because this is taking time from my billable work.
I have a related question for you.
Yes, sir.
Are you familiar with the client engagement letter?
Yes, I am. Client engagement letters is what we're talking about now.
Is there any language in there advising clients of the risks they take by storing documents on computers they don't own or that they share with others?
There is. He's asking if there is a specific language in our engagement letters about risks taken by clients. There is a mythical model engagement letter that includes all the stuff like, we're going to mark this up this much, you're going to pay for copies, and that's in there. That doesn't mean that every attorney is using the correct engagement letter. So that's, because we have a number of clients that are, we do insurance defense and a number of other high volume sorts of cases. So those folks don't pay for electronic research. They don't pay for much of anything other than the modified hourly rate that they're paying. So, whoever wrote that engagement letter they were so worried about including the correct things that they may or may not have put that in. And new matter openings don't require that the engagement letter be reviewed. They require that your conflicts get reviewed. I got a new job.
Conflicts checking?
Conflicts are checked, but they are only checked against our conflicts database. And I just got a new job, which is determining if we have worthy clients. That which used to be called clients of questionable quality, which is our insurer, our malpractice insurer, comes and does a little audit every 3-4 years, and this is something that came up around the same time that we started the security training. And now, all right, let me give you a small piece of, so you've heard we have 4 offices, we have 200 attorneys, we have 2 librarians. And we do everything the library does, plus a whole lot of other duties as assigned. I'm not sure how I'm going to be able to do client of questionable quality checks on every single new client. And we're still working through that because they'd rather not, because that takes time. but they don't want to they want to stay insurable, so it's kind of it's a challenge. Again, it's always this challenge. And yeah, this is an issue in all kinds of law firms because, especially if you've had a client for a long time, that information wouldn't have been in their engagement letter that they signed in 1972. So,
back to this organization of someone's entire life through their email.
yes.
How many emails is a young associate likely to have?
Oh, I would say that they probably have an inbox with 3,000, 4,000, 5,000 emails in their inbox.
What does the firm do to control or impact that?
Every 60 days, that's the retention policy. It just drops off, gone forever. Your deleted mail goes faster, and your sent mail goes faster than that.
How do young attorneys get whacked by this sometimes?
Yeah, occasionally that happens. What they're supposed to do is take their emails and put them into a folder in Outlook, and that folder is supposed to be attached to Worksite, which is the DMS, and it's supposed to automatically go there, and that fixes your retention issue. Now, they've still got a bazillion ephemeral emails, all this other stuff that, and so the retention policy doesn't look at the kind of email. It simply dumps, which is actually, unless we're under a litigation hold, we're ethically okay with that, which is kind of painful, but yes, there it is.
How much, what does the firm do to make folks aware of this?
You can actually open up an email and it'll say the retention policy is this will expire in, but
Okay.
it's up at the top.
It's little print.
Yeah, not something you're looking at. And I don't think anyone actually said anything to me when I started about what our retention policy was. Yes, sir.
Two-part question. Is the retention policy driven by storage concerns or regulation? And is there a data loss prevention or firewall to prevent associates from sending email to consumer Gmail or Hotmail or any other email of choice?
Okay, two-part question.
Two-part question, yep.
Yep, and
Well, I'll start with the second part. The second part is there any sort of firewall that keeps you from sending documents to Gmail, your own Gmail or whatever? No. There should be, but is there? No. And the first part was, again?
The retention policy driven by storage or regulation?
Oh, the retention policy is really driven by storage, but it ought to be driven by what our retention policy ought to be.
risk management.
Risk management. This is actually something that I've been preaching in my firm for a while. If we set up somebody's corporation, shouldn't we also, work on getting their retention policy up? And shouldn't we also be modeling good retention so that, first of all, that they go, oh, well, we ought to do that because that's what they're doing and they're a law firm and they know. Or also, when they get sued, it's not so painful.
I'm going to bounce us to something slightly different. What does a young associate do when they want to draft a document of any sort?
All right, well, often they will just start from scratch for no apparent reason. They might go search in the DMS for a document that looks kind of like their document. I've got people that go to Edgar and find the document that they want and pull it and then just start changing it. And we do have firm templates, but nobody forces any of those things to happen.
How good are your templates?
Our templates are pretty good. I mean, they have the right, especially from a technical standpoint, they're very good.
Technical legal standpoint?
Yeah,
Or
technical legal standpoint,
Okay.
in that they are going to have the right margins and the right stuff, so when you file it, it won't be rejected. But it doesn't have necessarily, it's not going to make sure that you strip your metadata or that kind of stuff.
Are all the templates, have the styles been set on them?
Yes, they have.
All right.
That doesn't mean they can't be unset.
Okay. And how transparent is all of that?
Well, it's It's transparent if you know what a style is. It's not transparent if you don't. Now, a really important thing that I'm not sure where y'all should teach this or where you should fit it in, but I'm guessing if you have any control at all over the writing class, that's the good place to do it, but, you know, or in an ALR class, and that is a concept. Okay, because we're talking all about skills and all this, but there's a big concept in law firms, and that is matter centricity. Everything lives and dies by your matter. So, in the DMS, you don't get to make new folders. Your folders are set based on the matters that you are dealing with. Each of them has, they're all set for either corporate, litigation, real estate, or IP. And you get a certain selection of folders when you do that. And if you need a new folder, you have to call IT. And they will make it for you if they believe that it is important. I don't even get to make new folders, and I don't work in a matter-centric world. So that is something that getting them to understand that it's just like having paper files. You have to put all the stuff in the right matter, or else you can't find it. Or if you get a litigation hold on a matter, let's say your client sues you over something about that matter, you got to have all that stuff in one place. So that's a concept that they need to understand. And then the rest of the stuff really is yes, skills are Outlook, Word, Excel, PDF, and an understanding of what metadata is and why it matters. Concepts, matter centricity, that there is such a thing as a document management system, that there are all sorts of rules that you're going to have to live by. They may be stupid, they may not make sense, they may not be applied equally, but they're the rules. And if you're going to work here, this is how you're going to do it. We can't download anything onto our machines and install it.
Can I ask you, who decides, who teaches the IT department when it's appropriate to create a folder?
Who tells the IT department when it's appropriate? Usually that would be something that a section head would tell them is okay.
And, I mean, deciding how to name it and...
Right, they would, how to name it and all that, that would all come, the attorney would say, I need one that does this, and they would send it to their section head and the IT department, and they would all get together and say, yeah, okay. And they'll name it what they name it, but it only exists for that one.
And when an associate saves a document
Yes.
into the matter, are there naming conventions?
No, there are no naming conventions, but there are also, it's not like naming things in a system where there are things you have to leave out, like periods and that kind of stuff.
Yep.
So they can write, it could have a 50-word title if you want it.
Now, the hierarchy in which they're saving it is established.
It is established, and all security trickles down through the hierarchy.
But is there anything that makes them put it in the right place?
No, other than that they're labeled basically emails, research, I think litigation all the time because that's a lot of what I deal with, but draft notes, memos, filing, things that are filed, all of that. So it's pretty extensive. And when we got the document management system, the new one, we went from a non-matter-centric to a matter-centric system. And that involved a whole lot of sitting down. It was actually done really well. Sitting down with practice groups and saying, what are the things that are common to every matter you deal with? We'll deal with the zebras later. Let's get your horses all set up. So that's one of the few times that I feel like they really did a very thorough job of setting it up, but it's also everything we do. So it needed to be done that thoroughly.
We're ticking down to the last 5 minutes of this. I've been asking questions. Those of you who are dealing with students, a few folks are popping up. Some of you need to be invited. I'm inviting.
And I do have one quick little thought also to remind them. None of their data is theirs. So that's another big concept, is that it all belongs to the firm.
What you got? Yes, sir.
What is the firm's policy, if any, regarding the use of social media inside or otherwise?
So the question is about the firm's social media policies, if any?
Well, we do. Our marketing department deals with firm social media. You're not supposed to obviously put confidential information on social media. If you are not using an official firm channel, you should not note that you are an attorney or a whatever of Smith, Gambrell, and Russell. You shouldn't talk about clients in any way, but no one's policing that. But it's something that we should be policing, but how? You can get to Facebook on our site. You can look, it hasn't been blocked. You can go there.
Speaking of which, you can get to Facebook.
Yeah.
Who knows you're going to Facebook?
Everybody in IT has the power to know that, so that's another thing. I know all of your students are smart enough to have heard, if nothing else, that everybody knows where you are all the time on the internet, right? Well, don't forget it, because our IT department can see almost to the keystroke what you're doing. So don't be stupid is basically, don't be stupid is probably one of my mantras on a regular basis.
Anybody else?
Do you tell the associates that?
Do we tell the associates that? Yes, they are told in that first horrible day where you sit down and you do your 3 hours of paperwork, and then you're sent to the IT trainer. There's one of them who teaches you how to use the phone and log in and do all this stuff. But that's the time you're told it. So it's not very much of this gets reinforced on a regular basis. So that's a policy issue, and it's a policy issue that we need to look into.
So you just slap a Banksy eye image on every monitor.
Yeah, something like that.
Yeah.
And, again, things to teach every thumb drive. If you come in with your own thumb drive, you stick that in, it has to become an encrypted thumb drive or you can't use it. That's also since September. September was a big month.
That sounds like.
But
it wasn't very long ago.
No, it wasn't very long ago.
Caroline?
Yes.
As far as presentation skills and formats, you've got Prezi, you've got the Mac app, you've got PowerPoint. Is there a firm style?
Yes. On presentations, is there a firm style? Yes, we have a firm template. It has Smith, Gambrell, and Russell and a little blue swoosh on every page. Unless it's for something specific. We do a collection of seminars that have very specific title pages. But otherwise, it also Smith, Gambrell, and Russell on every page. And no, you would never use Prezi. You would never use any of those other things because those are weird. And new.
Is there a department or is there a contractor that helps the litigation department with their visuals when they're going to trial?
No, unless it's again, this is that buying people thing, unless it's somebody who's always used this service.
Oh, okay.
Yeah, again, we get back to that, but that has to do with our particular acquisition model. It doesn't, if they're going to another firm that has always had these offices and has grown them organically, then it'll be different. And again, special snowflakes. So get them ready to be flexible they don't know what they're going to see, but don't terrify them into making them want to run away when they get someplace because it's completely utterly inflexible. Huh?
That's your job, everybody when they get there.
Yeah, but they need to understand that it's not going, that who knows what they're gonna find. And that, yeah, just because they like using something this way doesn't mean that that's what they're gonna get to do. So, you are all welcome to call me. Really, I mean it. Really, really. I think I've told everyone here at some point that they should call me. I have cards, I'll set them up here. And it has been a great pleasure to chat with all y'all. Yeah.
Dan, I used my y'all in the
Yes,
appropriate, in the appropriate plural. All y'all. Hi. We are thinking about doing some kind of a course for us. Thank you. So I've never worked in law. I tried to. I think presentation. The thing I'm going to do this year that I did not do last year is I think I'm going to have a module on just basic organization. I might, our university uses Outlook so everybody's got it. I think what I'm thinking about doing though is having them all bring up their official email and organize it. Create folders, think of an organizing scheme, even look at how you create filters to make things go to places that you expect them to go to. Because it struck me harder and harder that if they don't have those organizational skills, they're all really smart, which is great, but you can be so smart that you've never had to use organizational tools because you can keep it all, and they're not going to be able to do that at a point in their practice. And it's going to matter too much for them to be keeping it in their brain. Right, of course. Most of them are using SharePoint, so that means that it's been an individual setup. It's probably a contractor rather than somebody internal who set it up. The contractor may still be involved in it. So I mean, I think the systems are probably wildly different from the firm because SharePoint lets you do that. What do you got hook to hook? I think Sarah's right there that most firms have gotten to the point where their organization is matter-centric. Yeah. Thank you very much.
I am so interested in this, Maureen. I had no idea. This is a fabulous class. So what do you teach in comparison to what Sarah talks about? I mean, what do you actually teach to your students? And is it a 13?
No, they just added legal information special, that was silly, but they did it anyway.
I'm trying. Because I'm also in the IP caucus, so I'm in flip IP. Flip it. Yes, I'm in flip it. Hooray!
I'd like to see why.
That's a good idea.
Okay. I'd like to teach research. You're almost as an optional route between 3 Okay. That sounds interesting too, because I took this idea in Arizona research skills class, and the feedback I'm getting from my librarians is it doesn't seem like enough. So my other thought was, well, Arizona and other states do research, but it doesn't seem like enough. Okay.
Yes, thank you.
That was great. One thing to
drafted an update for you.
Okay.
I presume Carol's our contact at the ABA. So anyway,
Exactly.
No, I have not looked at the. I'm live. They told us that
That's live, yeah.
they're recording between sessions. So
Yeah.
I didn't take the tech tour to look at all the tools. That is
Where is
I guess that's an updated version of what we have.
Isn't it cool? But my laptop,
Yeah.
which is a modern laptop, wouldn't talk to it.
Really?
Even through the HDMI.
I'm going to give them.
It just wouldn't work for some unknown reason.
So is that, so y'all did have some slides or something?
No,
ready,
I
or
did
you
for a prior
For
one.
no, for the
Well,
previous
it wasn't
one,
even,
okay.
it wasn't even slides, it was simply a little like nice to have, it was an article that I'd
Sure,
written.
sure.
I'm gonna
That
make
included
them
stuff
spend
like,
this however
my
many
worksheet.
weeks in the semester they choose.
And it's in last, not this issue, but the last issue, it's
Yeah.
probably you can get to it, so.
So anyway, did they tell you why when to speak to the laptop, or they just, the tech guys couldn't
Yeah,
figure it out at all?
they just wouldn't talk.
I'm gonna talk about, the crazy thing that,
Anyway,
you can
so where's
never
your
be
firm?
sure.
Downtown?
is-
Not far?
No, we're in Midtown.
Any
Yeah.
kind of
Well,
matter where
Atlanta
whether
is
you have
a
to
weird
look
city
at
in that we
the
have all of our
Constitution,
businesses
the common
on
one laws, regulations,
Yeah,
the administrative.
Yeah, I
decisions,
And I walked down
you
a
know,
lot of it.
and
Somebody's told me that there's something, I think I'm really near your firm, I don't think you're not, you're staying
how
downtown.
those things happen.
No, we're at,
I'm gonna make
you're at
them-
200.
200,
They'll cover their
30
time,
and,
report their time working on this, give me, how did you find it? What is the primary law? What is the
So
primary
that's
law
gonna be,
you have to
this
do?
is gonna be,
This sounds good.
that's,
And see if that's.
Because I'm trying to think of
this
this.
is gonna be southeast, because the building is sort of
I took the
Only thing I
Honda
can
to
think of is.
the Midtown Station, which may be.
That's very close to where my office is, that's 10th Street. Yeah, and I'm at 15th, I'm at
He
15th Street,
actually
so I'm
did
at
take
the
us
art
down
center
to
station.
home to show us how to,
And I take
something
something
at 5 o'clock in the evening.
Nice to meet you.
Yes, yes, we got to talk, yeah.
I got a sense of what it was, but it wasn't really.
Good job, Sarah.
Thank you.
I think we're talking about. at
Well, you
all.
know I love standing up in front of people and saying
You know,
words.
this is a work in progress. I mean, I don't ever feel like I've gotten close to what I'm supposed to be doing.
What kind of numbers of students are you getting?
Last year I got 13 in the final analysis. We were up to about 16 and I shared the syllabus with them. And it's like 2 presentations, 2 short papers, 2 tests, and 2 skills tests.
That's not worth 1 hour.
That's too much work for 1 hour.
No, I understand that, yeah.
Well, and then, timing was bad.
Yeah.
The way it was scheduled was a pretty stinky time.
Did you have any trouble getting a bird?
We had a pretty good track record with Madison Street. So we weren't actually. And there were just some kids who were doing sounds like.
So are you sending out or sharing?
I'm gonna talk about it. Yes, I figured out.
Want to maybe make a decision.
Most of those recommendations.
One of the things that struck me most is that clearly there's no organization on the tech side.
Well, I thought the thing that you talked about, organization skills and stuff was.
How are you?
I'm not sure the best way to
I
do
Good.
folks who are teaching technology are trying to get it. Doing it a little.
I think this is
I
just.
picked myself up. I was in the car for hours.
This is a niche that's huge, especially in this day and age where you're not 100% sure where our jobs are going.
I've got, I don't.
That's a whole other world. I think that's.
Right.
I didn't practice it. Well, and I didn't actually practice that. Masters, so. Okay, nice presentation. Yes, thank you. It's later. I don't see you. Which one? We'll be in touch.
Oh, wait.
Yeah, no questions.
Wait, so then you would go back and check.
As I said, I'm a problem.
I did. I have not seen it yet. I really, I love to do that. So we have
My whole chicken was great.